Hello and welcome to Law Now. What does it truly mean to be an Indian citizen? And who is considered an Indian citizen according to the Constitution? Is it just about holding a passport, or is it something more, woven deep into the fabric of our history, culture, and identity? A citizen is defined as a person belonging to a territory and having the power to exercise their rights over that territory. In simple terms, citizens are bound by law and are considered full members of any state. Citizenship itself is a concept that defines the relationship between an individual and their sovereign state. The people can be categorized into two groups: citizens and aliens. In our context, those who are not citizens of India are considered aliens and are consequently excluded from citizenship rights. In India, citizens are full members of the Indian state and owe their allegiance to it. They also enjoy all civil and political rights. Aliens, on the other hand, are citizens of another state and do not enjoy all the civil and political rights. Here's a breakdown of the rights and advantages that the Indian citizens have over the aliens, as well as the rights aliens retain according to the Constitution. Rights available only to Indian citizens. Protection against discrimination. The rights given under Article 15, that is the right not to be discriminated against on the grounds of religion, race, caste, sex, or place of birth. Equality in public employment. Article 16 guarantees the right to equality of opportunity in the matters of public employment, which is available only to Indian citizens. Freedoms. The right to freedom of speech and expression, assembly, association, movement, residence, and profession, as defined under Article 19, are exclusive to Indian citizens. Cultural and educational rights. Rights under Article 29 and 30 are only granted to Indian citizens. Political rights. The right to vote in elections to Lok Sabha and the State Assembly is reserved for citizens. Only citizens can contest for membership in the Parliament and state legislatures. Eligibility for public office. Certain high public offices such as the President and Vice President of India, judges of the Supreme Court and High Courts, governors of the states, Attorney General for India, and the Advocate General of states can only be held by citizens. There are some rights which are also available to aliens. These are equality before law, given under Article 14, and protection of life and personal liberty, which is given under Article 21. Articles 5 to 11 deal with citizenship in India. Citizenship is normally a matter to be dealt with by legislation rather than being incorporated in the Constitution. It is, however, not unusual or unknown to have provisions on citizenship in the Constitution of the country. In view of the extraordinary situation caused by the Declaration of Independence associated with the partition of the country into India and Pakistan, and freedom to the Indian states to join either of the two countries, the question of citizenship became particularly important at the time of the making of our Constitution, because the Constitution sought to confer certain rights and privileges upon those who were entitled to be Indian citizens, while they were to be denied to aliens. The provisions in this part became necessary, while with the lapse of time since the commencement of the Constitution, most of these provisions, that are Articles 5 to 10, have become of historical interest. Only one provision, which is Article 11, remains relevant for the future. The purpose of Article 11 also would have been served by Article 246(1), read with Entry 17 of List 1, Schedule 7. But in the view of preceding Articles 5 to 10, Article 11 serves the purpose of removing any doubt that could be entertained about the absolute and exclusive power of the Parliament to deal with matters of citizenship in India. So now let's start with Article 5. Citizenship at the commencement of the Constitution. At the commencement of this Constitution, every person who has his domicile in the territory of India and A. who was born in the territory of India, B. either whose parents was born in the territory of India, or C. who has been ordinarily resident in the territory of India for not less than 5 years immediately preceding such commencement, shall be a citizen of India. Article 5 basically talks about citizenship by domicile of the people during the commencement of the Constitution. Domicile in India is considered an essential requirement for acquiring the status of Indian citizenship. but the term domicile is not defined in the Constitution. The domicile of a person is that country in which they either have or are deemed by law to have their permanent house. So there is a difference here between domicile and residence. Residence alone in a place is not sufficient to constitute the domicile. It must be accompanied by the intention to make it their permanent home. But it is basically a legal concept for the purpose of determining what is the personal law applicable to an individual, even if an individual has no permanent home. They are vested with a domicile by law. There are two main classes of domicile, which is domicile of origin and domicile of choice. While the former attaches the individual by birth, the latter is acquired by residence in territory, subject to a distinctive legal system with the intention to reside there permanently. Two elements are necessary for the existence of a domicile. One, a residence of a particular kind. Number two, an intention of a particular kind. The residence need not be continuous, but it must be indefinite, not purely fleeting. The intention must be a permanent intention to reside forever in the country where the residence has been taken up. Thus, there must be both factum and animus to constitute the existence of domicile, for neither domicile nor mere residence is sufficient to make them an Indian citizen. Domicile with 5 years of residence was necessary to make them a citizen. In Pradeep Jain versus Union of India, the Supreme Court has held that in India, Article 5 recognizes only one domicile, that is, domicile of India. It does not recognize the notion of state domicile. When a person who is permanently a resident in one state goes to another state with intention to reside there permanently or indefinitely, his domicile does not change and he does not acquire a new domicile of choice. India is not a federal state in the traditional sense of the term. It has only one citizenship, and that is the citizenship of India. It has also one single unified legal system applicable throughout the country. The concept of domicile has relevance to the applicability of municipal laws, whether made by the Union or by the states. In Louis de Rader versus Union of India, the petitioners, who were foreign nationals, challenged the order of the central government expelling them from India on their failure to acquire Indian citizenship. The petitioners came to India before independence and were staying continuously on the basis of a foreign passport and residential permits. They were engaged in Christian missionary work. They contended that they became citizens of India by virtue of Article 5C of the Indian Constitution, as they were staying in India for more than 5 years immediately before the commencement of the Constitution. The court held that they failed to establish that they had an intention to reside in the country permanently. The petitioners did not have a domicile in India. For the acquisition of a domicile of choice, it must be shown that the person concerned had a certain state of mind, the animus manedi. If he claims that he had acquired a new domicile a particular time, he must have proved that he had formed the intention of making his permanent home in the country of residence. Residence alone, unaccompanied by this state of mind, is insufficient. Domicile of origin is lost only on acquisition of domicile of choice, and not on mere continuous stay in another country. Let's come to Article 6. Article 6 provides that a person who has migrated to India from Pakistan shall be deemed to be a citizen of India at the commencement of the Constitution, that is 26th of January 1950. If he or either of his parents or any of his grandparents were born in India as defined in the Government of India Act 1935, and in addition to the above condition, which applies in both cases, fulfills one of the following two conditions. 1. In case he migrated to India before July 19, 1948, the date on which permit system for such migration was introduced. He has been ordinarily residing in India since the date of his migration. In case he migrated on or after 19th of July 1948, he has been registered as a citizen of India by an officer appointed by the Government of India for that purpose, provided that no person shall be so registered unless he has been residing in India for at least 6 months immediately before the date of his application for registration. If the above conditions are satisfied, a person shall be deemed to be a citizen of India. Let's come to Article 7, Rights of Citizenship of Certain Migrants to Pakistan. Notwithstanding anything in Article 5 and 6, a person who has, after the first day of March 1947, migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India, provided that nothing in this article shall apply to a person who, after having so migrated to the territory now included in Pakistan, has returned to the territory of India under a permit for resettlement or permanent return issued by or under the authority of any law, and every such person shall, for the purposes of Clause B of Article 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. Article 7 thus overrides Article 5 and 6. Both Articles 6 and 7 use the term migrated. The meaning of the term migrated came for consideration before the Supreme Court in Kulathi versus State of Kerala. According to the court, the term migrated used in Articles 6 and 7 has to be construed with reference to the context and purpose and the prevailing political condition at the time the Constitution was being enacted. So interpreted, the word migrated could mean nothing except voluntarily going from India to Pakistan permanently or temporarily. The majority held that the word migrate was used in a wider sense of moving from one country to another, with the qualification that such movement was not for a short visit or for some special purpose. Thus, it is a question of fact whether a person has migrated to or has gone to Pakistan on a temporary visit only, and has to be decided on the facts and circumstances of each case. Citizenship comes to an end only when there is a migration and not where there was only a temporary visit. But in the context of the Constitution, it has the notion of transference of allegiance from India to Pakistan. A temporary visit on business or otherwise cannot amount to migration. In the case of State of Bihar versus Kumar Amar Singh, 1955, a woman traveled to Karachi in July 1948, leaving her husband in India. She claimed her trip was for medical reasons, but this was deemed unfounded. She obtained a temporary permit stating that she was domiciled in Pakistan and a Pakistani national. She returned to India in December 1948, but went back to Pakistan in April 1949 after her permit had expired. Despite her efforts to settle permanently in India, she failed. When her property in India was being given to a custodian, she claimed Indian citizenship. The Supreme Court held that she had indeed migrated from India after the 1st of March 1947 and clarified that Article 7 overrides Article 5, making no exceptions even for a wife migrating to Pakistan while her husband stayed in India. Now let's come to Article 8, Rights of Citizenship of Certain Persons of Indian Origin Residing Outside India. Notwithstanding anything in Article 5, any person who, or either of whose parents or any of whose grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and who is ordinarily residing in any country outside India as so defined, shall be deemed to be a citizen of India if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country where he is for the time being residing. On an application made by him, therefore, to such diplomatic or consular representative, whether before or after the commencement of this Constitution, in the form and manner prescribed by the Government of the Dominion of India or the Government of India. So basically, Article 8 provides that any person or either whose parents or any of whose grandparents was born in India as defined in the Government of India Act 1935, who may be residing in another country outside India, shall be deemed to be a citizen of India, as if he has been registered as a citizen of India by the diplomatic or consular representatives of India in the country where he is for the time being residing. So Article 8 confers citizenship on Indian nationals residing abroad on their complying with its provisions. Now let's come to Article 9. Article 9 provides that if a person voluntarily acquires the citizenship of any foreign state, he shall not be able to claim citizenship of India under Article 6 and 8. It deals only with voluntary acquisition of citizenship of a foreign state before the Constitution came into force. Cases of voluntary acquisition of a foreign citizenship before the commencement of the Constitution will have to be dealt with the Government of India under the Citizenship Act of 1955. Now comes Article 10, which provides that every person who is or is deemed to be a citizen of India under any of the foregoing provisions shall continue to be a citizen of India, subject, however, to the provisions of any law that may be made by the Parliament. Thus, in exercise of this power, Parliament may take away the right of citizenship of any person. But the right to citizenship given under the foregoing provisions can only be taken away by an express law made by the Parliament. It cannot be taken away indirectly. In Ibrahim Wazir vs. State of Bombay, the constitutional validity of Influx from Pakistan Control Act 1949 was involved. This act provides that no person domiciled in India or Pakistan shall enter India from Pakistan without a permit. If a person enters India without a permit, he commits an offence under Section 7 of the Act that authorizes the central government to direct the removal from India of any person who has committed or against whom a reasonable suspicion exists that he has committed an offence under the Act. The Supreme Court held that Section 7 was ultra vires of the Parliament because to allow the forcible removal of an Indian citizen from India would be tantamount to destroying the right of citizenship conferred by Part 2 of the Constitution. The right of citizenship, the court said, could only be taken away by recourse to Article 11 of the Constitution. Thus, in absence of any law expressly made under Article 11, the right of citizenship cannot be destroyed by an act made for a different purpose. Now we come to Article 11, the power of Parliament to regulate the rights of citizenship by law. Nothing in the foregoing provisions of this part shall derogate from the power of Parliament to make any provisions with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. The Parliament has the power to make laws with respect to citizenship, naturalization, and aliens. The object of this article is to make it clear that notwithstanding the fact that certain rules relating to citizenship are contained in Part 2, Parliament shall have unfettered power to make any provision relating to acquisition, termination, etc. of citizenship. Parliament, in exercise of its power, has enacted in 1955 the Citizenship Act. This act provides for the acquisition and termination of citizenship. Several changes were made in the Act in 2003 and 2005 to introduce the concept of overseas citizenship of India, especially with a view to facilitate the dealings of Indian diaspora with India. The Citizenship Act 1955 is the primary legislation that governs how Indian citizenship is acquired, maintained, and in some cases terminated. It sets out the various modes by which a person can become a citizen of India and specifies the rules and procedures for each. Although the Act has been amended several times over the years, its basic structure is organized into sections that deal with definitions, modes of acquisition, and related administrative matters. In this video, I will be giving you a brief overview of the key components of the Citizenship Act of 1955. And I will be making a full detailed video about citizenship in India in the coming days. The preliminary provisions, Section 1, which is short title, extent and commencement. Section 2, which gives the definitions of the words such as citizen, Indian, etc. And then we come to the modes of acquiring citizenship in India. The Act lays out several methods through which citizenship can be obtained in India. Section 3 lays out citizenship by birth. This specifies that a person born in India on or after a certain date is a citizen by birth, subject to certain conditions. For example, the status of the parents may be taken into account. Section 4 deals with citizenship by descent. Individuals born outside India who may be eligible for citizenship if one or both parents were citizens at the time of the person's birth. This section details the requirements and documentation needed to establish such a claim. Section 5 deals with citizenship by registration. which provides for the acquisition of citizenship through registration. This is often relevant to persons of Indian origin residing abroad or to foreign spouses of Indian citizens, subject to eligibility criteria such as residence requirements and language proficiency. Section 6 deals with citizenship by naturalization. This outlines the process through which a foreign national can become an Indian citizen. It sets forth the conditions that must be met, such as a minimum period of residence in India, evidence of good character, and an understanding of the rights and obligations of citizenship in India. Section 7 deals with incorporation of territory. This explains that when a new territory becomes part of India, the residents of those territories may automatically acquire Indian citizenship under certain specified conditions. The process of termination of citizenship and renunciation are also mentioned under this Act. Section 8 is concerned with renunciation. It allows any Indian citizen who is an adult and of sound mind to renounce their citizenship. They must follow certain specific procedures, and once their declaration is registered by the government, they lose their Indian citizenship. If this declaration is made during a time of war, the process is temporarily paused. Also, if you have minor children, they too lose citizenship unless they choose to resume it after coming of age. Section 9. Termination by acquisition of foreign citizenship. It deals with automatic termination. If any Indian citizen voluntarily acquires citizenship of another country, they automatically lose their Indian citizenship. However, during wartime, this may be suspended until the government directs otherwise. Section 10. Deprivation of citizenship. It allows the government to deprive someone of their citizenship if it was obtained through fraud, if the person shows disloyalty to the Constitution, or if they have been absent from India for an extended period. This process includes proper notice and the opportunity for the person to be heard before any decision is made. Now, there have been certain amendments that have been made to the Citizenship Act of 1955, which have played a significant role in shaping the framework for acquiring, retaining, and losing Indian citizenship over the decades. And here's the overview of the major amendments. The 1986 Amendment. This amendment responded to the concerns raised during the Assam agitation. It altered provisions relating to citizenship by birth, effectively restricting just solely citizenship by birth on Indian soil for children born to non-citizens. The amendment aimed to curb the automatic granting of citizenship to children of illegal immigrants and to address issues highlighted during the Assam movement. The Amendment of 2003, passed in response to the growing concerns over illegal immigration, particularly from Bangladesh. This amendment introduced the concept of illegal migrant. It made it clear that illegal immigrants, those entering or staying without valid documents, would be ineligible for citizenship by registration or naturalization. It also laid the groundwork for creating a national register of citizens by requiring better documentation and stricter criteria for naturalization. The 2005 Amendment or Ordinance. Shortly after the 2003 amendment, Citizenship Amendment Ordinance 2005 further modified the Act. Notably, it led to the creation and regulation of overseas citizenship of India, providing a separate status for people of Indian origin residing abroad, while reinforcing restrictions on illegal immigrants. 2015 Amendment. This amendment addressed issues related to the registration and naturalization processes and further refined the provisions for the OCI card holders. It also updated certain criteria and streamlined procedures in part to facilitate the growing complexities of citizenship issues in a globalized world. Now comes the 2019 Amendment. This is the most recent amendment added a religious criterion to naturalization process by fast-tracking citizenship for members of 6 minority communities which are Hindus, Sikhs, Buddhists, Jains, Parsis and Christians from Afghanistan, Bangladesh and Pakistan who arrived in India on or before December 31, 2014. This controversial amendment has also sparked widespread debates and protests around the country, as critics argue it violates the secular principles enshrined in the Constitution by excluding a single community on religious lines. Now, each of these amendments reflects shifting priorities and political contexts, from addressing illegal immigration and preserving the cultural identity of certain regions like Assam to introducing more controversial criteria based on religious identity. The 1986, 2003, 2005, and 2015 amendment focused mainly on tightening citizenship criteria and clarifying documentation requirements. The 2019 amendment represents a marked departure by explicitly incorporating a religious factor in citizenship determination. So this was Citizenship in India from Articles 5 to 11, and a brief overview of the Citizenship Amendment Acts concludes our video. So thank you for watching. I hope you got to learn something new. Please subscribe to my channel and help me boost your legal IQ.